Hello, everyone. I first just wanted to welcome you to tonight's webinar. Before we get started, I just want to go over a few housekeeping notes. So everyone's cameras and mics are off, so rest easy. You can relax. No one can see you or hear you, so you do not need to worry. A bit about the structure today. Dan Griffin will be presenting an overview for the first 15 or 20 minutes. We'll then open it up to questions, some which have been already submitted, and you'll also have the option of submitting questions as we go through tonight's presentation. Speaking of Q&A, to submit a question, you should see a button at the bottom of your screen if you're on a phone or on a desktop. And there you'll be able to submit an anonymous question that we will share with Dan during the Q&A section. Our goal will be to get to all the questions, again, some which have already been submitted. And at the same time, though, we do want to honor our 1 hour time commitment tonight and everybody's time. So we will do our best to get to all the questions today. Finally, you will get a copy of the recording. You'll also get some notes and an attachments by email tomorrow. So rest easy, enjoy. Please feel free to ask any questions throughout the presentation, and we will try to get to them. So we'll get into it. For those of you who don't know me, my name is Anuja Pereira. I am the owner and founder of Seamless Rightsizing. Seamless Rightsizing is really full service real estate. And the goal of it is to help folks who are seniors with all aspects of their move, from deciding if it's time to get right-sized, to getting the house ready, bought, sold, and buying a new place or renting into a new place, all the way into getting settled into your new home. And my goal is really to help take the overwhelm out of the process, to help people seamlessly get into a right-sized home. A big part of that is certainly education. And so tonight is the first part of a Rightsizing Readiness webinar series. I just want to share with you that we are already scheduled for the second webinar, which will be taking place on January 28th with a professional organizer named Hilda Rogers from Overwhelmed to Organized. And she will be sharing some tips and tricks on how to get rid of some of the stuff that may be weighing you down in your home while maintaining and cherishing the memories that you have. So stay tuned. You'll get some information about how to register, but you can mark that date in your calendar, January 28th, with Hilda Rogers. So one of the things that happens in my experience in working with seniors and families is that I realize that many people are not prepared. Only, I think, 48% of Canadian adults have a will. And not being prepared can lead to a lot of confusion, a lot of stress, and can often even lead to some conflict with families. And so that's why we are here tonight. I've invited Dan Griffin of Goodman and Griffin, who is a wills and estates lawyer, who I trust with many of my clients, who I trust with my personal real estate needs. And he is a fantastic person and resource and has given us some time here today. So we look forward to that. So I'm just going to invite Dan into the mix, and we should be able to see Dan. All right, Dan, can you try talking for us? How's that? Oh, there we are. Hi, Dan.
Hi, can you hear me okay?
Yeah, we can hear you. Thank you so much for being here. Before we get started, Dan, we were just going to throw out a quick poll. If you're on a phone or on your computer, you should see a button with some almost like a bar graph, and it's asking you a question. When did you last update your will? So if you can all just take a quick second. Dan, it's going to give us a sense of maybe who's in the room, where we're all at. All right, so I'm just going to share this in case anyone wants to see. It looks like 27% of the folks here today, 33% have completed a will within the last 5 years. 33% 5 to 10 years ago, 8% 20 years or longer, and 25% of the people here, Dan, are here for a reason, and that's because they have not worked on their will. So that's a really interesting, some interesting numbers for us to understand that, again, really similar to what we see across Canada is that many people don't have their wills done yet. So that's where we are, Dan. I'm going to get into your presentation. I may ask some questions along the way, and then we'll open up for the Q&A. Does that sound good?
Great.
Okay, perfect.
All right. So thanks, Nuja and David, for having me today. And I can't see anybody, but I assume you're all very good looking and nice people. So it's a pleasure to be joining you tonight, and hopefully this will be useful for you. And I encourage, if you have any questions or there's anything we can do for you during the meeting or after, you'll know where to find me if you'd like to follow up as well. And just to say a couple words about Anuja and David too. I've worked with a lot of different associates and real estate agents and people in the industry over the years, and they are definitely some of the best. And I think that you'd be in good hands to hire them to help you out as well. So I appreciate being a part of this tonight. So we want to basically just kind of give you a sense, first of all, of who I am. And so I'm a lawyer at Goodman and Griffin. And I do focus, my practice is on wills and estates, as well as residential and commercial real estate. So, the bulk of the transactions we do will be, helping people buy and sell their houses, as well as helping people prepare their wills and powers of attorney. And so helping with their estate planning. And that's really across the board. Sort of regardless of their socioeconomic background. And we have a variety of different kinds of estates that we deal with. And so I think, the point really is that this is for everybody to think about. This is something that can help everybody, no matter what, walk of life you're in, and at various points in your life, especially when you acquire, lots of young couples as well, when they acquire their first property and they're starting to build a family, it's a perfect time to think about their will. Later in life, it's a great time to think about your will, because these are things that are ultimately going to help save you and your family a lot of grief that they're already going to be dealing with at a very difficult time. These are things that just make the process a lot easier for everybody. So that's part of what I try to communicate to my clients when we're putting together a will, is not just about maximizing, cost effectiveness, which of course is part of it, and avoiding the impact of taxation as much as possible. But a big part of this is also how to create a document that balances the interests of the testator, the person that is the deceased, with the job that they've given to the executor or the trustee that's now responsible for communicating, and dealing with their wishes and making sure that all of the gifts go to the right people, making sure that their life isn't too difficult too. And so that's a balance, of sometimes less can be more in the instructions. And so we kind of work with this communicative and collaborative approach to trying to make sure that ultimately you and your family are on the right path. So that's where I'm coming from. G&G, Goodman and Griffin, has been around for over 45 years now in the Mississauga area. Back when Wally's was the only place you could go to eat on Ontario. And so we're one of the oldest firms. We're a family-run firm. I'm obviously the second generation, if you couldn't tell. So we have been in this area and proud Mississauggans for quite a while. So it's always a pleasure to help people in the GTA you know, and in the community. So that's a little bit about myself. What should we move on to next, Nuja?
I'm not sure if you can see that, Dan. Could you see the slide before?
1 second. I still have the poll up here. Okay, there we go. Very good. So I'm hold on 1 second here. I don't think I can see the slide yet. I just want to make sure that I'm looking at the right thing here. But if not, I have.
Oh, you know what? I think it was me. Sorry about that. I'm not sure what happened there. Let's do that. How's that? There we go. Dan, I can't hear you. Oh. See you and I can't hear you. There we go. Dan, we're not hearing you for some reason. Try now. There we go.
It wouldn't be a show if we didn't have some technical difficulties. It's just, this is all, we're doing this on purpose just to prove that it's live and not.
There you go.
Pre-taped. So we want to talk about what the common mistakes to avoid are, you know, in bringing together a will and a power of attorney. Now, just to back up just a brief second. So when we're talking about a will, we're talking about a document that has basically your instructions to the executor who you've appointed to, you know, do a variety of things once you're deceased. And that deals with transferring your assets, personal belongings, and it also can contain things that are not binding to the executor, but are wishes that you want. For instance, dealing with your burial wishes, or even wishes to beneficiaries about how you want them to deal with certain assets going forward. So while maybe you can't restrict certain things, there are obviously there's an opportunity to communicate those wishes to your loved ones, to the beneficiaries as well as the executor. Now, powers of attorney.
Dan, just a question. Dan, just a question. As you said that, I was thinking, are those binding? So they might not be binding by the executor, but let's say in my will I put my wishes, for example, for cremation. How is that enforced if it's not through the executor?
It's not, and that's an important thing to keep in mind. There is no way to enforce that, and one of the reasons is because, you know, for you know, the executor, it may not, for instance, have, you know, there may not be enough money in the estate to deal with these things a certain way. There may not be at that time the availability of certain burial methods. So these things are not binding from a legal perspective to the executor. In other words, the executor is not obligated to report to the court and saying, I did bury them in this manner in which they you know, wanted me to. The will is really at its core about dealing with assets and money. And so these things, sort of peripheral wishes, even though they aren't binding in that respect, it is something that you can communicate, and that, you know, obviously an executor who cares about making sure that your wishes are respected, which, you know, is goes to one of the items on this list here. You know, making sure that the person you've appointed knows how you would want them to act, and also that they have a certain amount of parameters legally, you know, in the will where they have to do certain things. So So there is going to be elements of this that you're not going to be able to control. And one of those is burials. Another thing is restrictions on transfers after your death. So for instance, you can't control what, if you've transferred let's say a house to your son, you can't control what then he does with that house after the fact. Restrictions on marriage are invalidated. There are a variety of things, religious restrictions, etc. There are things that have been ruled invalid over the years through the case law. So basically, we're talking about assets and transfers of those assets to people in your will. Now, powers of attorney are very different. This is also called a living will, and what they relate to is, decision making on your behalf in the event that you are incapacitated. So this could be either for a health reason, if you were in a coma, or you were in some sort of state where you weren't be able to give verbal communication. If you were out of the country and you wanted someone to deal with your affairs for any kind of reason that you can't represent yourself in that moment, a power of attorney would then come into effect. And so they're very powerful documents because the people that you appoint are going to have broad powers and responsibilities to make decisions for you, both in personal care and in property. And those are the two main powers of attorney that we draft for our clients.
And Dan, sorry, Dan. Quick question: once someone passes, then the powers of attorney are nullified and superseded by the will, I presume?
So the powers of attorney only deal with when you're alive, but you can't make decisions on your behalf. And so, like we said, these are situations where someone might be suffering from dementia, or they're in a comatose state, or for whatever reason, but they're still alive and they require care and often decisions about property, sometimes for the purpose of liquidating property in order to pay for their health care. So these are very important documents, especially for people who are aging, who want to make sure that their loved ones not just have the authority to make decisions for them and to take care of them when the doctor asks who is the power of attorney in the room, but also that they're going to be able to make decisions for them in order to generate the kind of money that they might need for health care or ongoing care in home or whatever it is. So these items here, are important. Obviously, when some of the errors people make or mistakes people make in their life over the years of having drafted a will, sometimes 20, 30 years ago, like some of you have, life has changed. You may have grandchildren that have become adults. You may have children that have passed away. You may have new friends, new family members that you want to step into those positions that you had, appointed people 20 years ago that you feel like would be better suited to that position. So, and of course, there's divorce. Any major life change is a good time to take a look at that will and that power of attorney document and make sure that it still reflects, what you would want now. And another thing that happens is sometimes people don't name alternate. So for instance, they might say, I want my husband to be my executor. But if your husband passes away, 10 years later, and you haven't appointed an alternate, well, now we're in a position where where someone is going to have to apply to be the estate trustee with a will, and basically, be in a position where they're going to have to take administrative steps. They're going to add time and cost to the process. So adding, alternates is always a good idea. Adding alternates to gifts as well can be a good idea as well for the same reasons, so that gifts don't what we call lapse or don't have any place to go. So these are all things that we talk through with you to make sure we've not gone overboard, but that we have sort of backup scenarios. I think we can move on to the next slide here.
Can you see that, Dan?
Yeah, perfect.
Yeah.
Yeah, so this is a good example of just, we're talking about people that, if you're an executor or someone who's been appointed power of attorney, these are people that you really, not necessarily even that are the closest to you, but they should be somebody that not only you trust, but that are organized and are functional and are able to take on what could be, depending on the size of your estate, quite a complex and long process. And so it's a difficult task. It's something that people look at, I think, as a can be an honor, it can be a responsibility, it can be a burden, but all of these things really are best dealt with by someone who cares a lot about you and is willing to do what's necessary. Now, some people, as they age or even earlier in life, don't have someone that they think of who could fill that position. And in those scenarios, we have offered to step in to be appointed as executors. The role is the same for us. It's not unusual that either a trusted professional, an accountant, or a lawyer will be appointed, and we basically would take the same position that a family member trustee would, which is that we would, go through all of the same information and make sure that all of the proper paperwork was done, and that ultimately the gifts end up where they should. So that's an option to people as well that we, in those cases, can offer. Some banks are starting to do this as well, although, as a caveat, I think it's important to note that banks will have sometimes a more rigid or stricter sort of requirements around what their fees are, and what their sort of or their commissions are, and it can add bulk to the will and to the process of drafting the will, but that's an option as well. A financial advisor can certainly help you with that.
Perfect. Just a quick question about an executor. If it is a family member, Dan, is that generally something that they're compensated for, or is that, like you said, sort of an honor and a responsibility and something you're doing for someone?
Yeah, it is generally something that people are expected to and entitled to compensate themselves for. I mean, it is quite a lot of work. It can be anywhere between 30 to 90 hours sometimes estimated in terms of, and even longer. It can take months to sort of, to go through the process of probate. And so the general, in the Estates Act, there's no specific amount, but generally the sort of accepted reasonable standard of compensation is 2.5% in on all the assets that are coming into the estate, and then 2.5 out. So essentially 5% is the kind of commission or the compensation that a trustee would be entitled to from a reasonableness standard. And they submit all of their time, their docket, their time to the court as part of the passing of accounts, it's called. And so this is, to a degree, reviewed and audited as well by the beneficiaries, who are entitled to review the passing of accounts to make sure that it is all reasonable, and so there's an opportunity to object if it's if they believe that it hasn't been handled in a cost-effective way. But that's generally the rule is around 5%.
Okay, perfect. Next, we're going to talk a bit about probate and taxes. So if you could just tell us, you've used the word probate a fair bit. I know I want to preface this with knowing that you are not an accountant. And so there will be some questions. Certainly, I know in our house, we talk a lot about trying to, legally minimize the amount of tax we're paying. So if you could talk a little bit about that while staying within your role and what you're comfortable with, that would be fantastic.
Yeah, absolutely. So, and it's important, I think, to recognize too that the role of a lawyer and an accountant are very important in this process, because when we talk about probate, we're talking about an administrative tax essentially that the province charges on an estate, for transferring assets through that estate to another person. So it's different than our capital gains, for instance, or in general the taxation that you're going to be like from the CRA. So it's really best way to think of it is an administrative tax, and it's 1.5. It goes up depending on the value of the estate, but generally, let's just say it's about 1.5 of the total value of the estate, 1.5%. And you can just think of it as a fee, an admin fee that the government, that the province charges for essentially, doing the administrative part of transferring the assets in an estate. So the question of how to minimize it has to really do with trying to see what assets don't need to go into the estate on your death, because whatever doesn't go to the estate and doesn't need to be transferred to the estate and doesn't require the estate as the authority to then transfer it to someone else, that won't get taxed. That's the idea. It'll still be subject to your capital gains tax, income tax, etc., right? But it won't be subject to this admin tax. So how do we do that? Well, there's a few things here. One way, which you may or may not have heard about, is about using joint tenancy. So for property, okay, a lot of you own property, a lot of you have spouses that you own property with, and you probably, when you purchased the property, went on title as joint tenants. And what that means is that you have an equal, undivided interest in the property. And if one of you predeceases the other, then the survivor automatically is, your interest is automatically transferred to the survivor. And that's a trigger that happens essentially the second before you die. So it's not, it does not enter your estate. It's an asset that is excluded, and so it's not subject to probate tax. Now, if you don't do that, okay, or let's say your spouse already passed away and now you're the only owner of this property, and then in your will you say, I want my daughter to have this house. Well, then the estate has to, then the property has to go into the estate, and then the estate will pay probate tax on it, and then it will transfer it to your daughter. And so, that's what happens if you don't have anyone left on title as joint tenants. So that's one way that people do it. They say, well, I'm just going to add the person as a joint tenant, and that way, when the time comes, when I pass away, they will automatically become the owners. Now that's a way of planning it. There are, cost benefits to that as well, but generally that's a tactic that's used often. Another way to do it. Oh yeah, go ahead, please.
I was just going to say, what if there are 3 children or 4 children or 2 children? Is it wise to have both children on title, or is it generally just one of them and then it's dealt with?
Yeah, I mean, it's totally, there's nothing wrong with adding multiple parties as joint tenants on title, especially if they are ultimately going to, be gifted the property. But there are things that you want to think about, for instance, that for each individual that might make a difference in terms of why you bring them on or why you do it at all. There are tax implications for that individual. They will have been deemed to acquire the property at fair market value at the time of that transfer through survivorship. They may not have the money to pay, you know, to pay property taxes on it going forward, or to keep it upkeep and maintenance. They may not be able to pay for the cost of, you know, they may just not be interested in having a property. They'll lose their first-time home buyer rebate, you know, which is $4,000. So these are all kind of just considerations. Sometimes it's better to think, well, I'll, you know, just eat the probate tax. The estate will pay 1.5 and liquidate the property and give the cash to the kids, because, you know, that doesn't come with any other responsibilities. You know, so sometimes, especially when we're talking about cottage properties, you know, properties where it can be very complicated, a lot of people involved, a lot of people interested, sometimes the best way to handle it is just to say, you know, if, unless we're going to spend some money on coming up with an agreement, some sort of partnership agreement, we might be better off just, you know, saying goodbye and to the place, and everybody can figure out, you know, buy themselves a little cabin. So that is you know, to be taken into consideration with the savings as well. Another thing that people can do is designate beneficiaries on their certain accounts. So RRSPs, TFSAs, insurance, life insurance policies. As long as there is a direct route for that money to go that's triggered by your death event, essentially, you know, then that's money, or that also doesn't have to go into the estate. So that's another asset that won't be subject to that administrative tax. And so that's what you're thinking of. You know, how many things can I basically set up to have an automatic transfer? And there are these tools that you can use, and there are sort of you know, advantages and disadvantages to them. So this is a conversation you have not only with your lawyer, but with your accountant as well, who is going to be able to sort of, you know, crunch the numbers and come up with whether or not this makes sense for you and your beneficiaries going forward. Yeah.
Dan, just a question that's come in related. What's the mechanism to make someone a joint tenant? Do you just simply put them on title? But what can you do to avoid transferring the estate today? So if I want to add my daughter onto title, how do I not trigger a transfer but add her on? What's that mechanism?
You can't. It is a transfer, and any change of title is going to be a transfer. So, you know, it's going to cost, from a fees perspective, it's going to be roughly the same as transferring it to a third party, right? You know, and so that's part of the assessment of whether it makes sense for you and the beneficiary. But in general, you know, what you do is you go to a lawyer, a real estate lawyer, like us, and you say, you know, I'd like to transfer this to my daughter, and I'd like to retain ownership as well. And then it's, you know, that's basically how we set it up. And then, you know, you and your daughter sign the necessary documents, and then ultimately, you know, we register a deed in the name of both of you as joint tenants, and then that's all you need to do. You know, and then your daughter would be entitled to that survivorship, and vice versa, in the event of one of you passing away.
And if that child is a minor, would that be something that you just didn't do yet?
Right. Yeah, you can't do that. So, you know, when we're dealing with minors, that's one of the reasons that we would look to the will to ensure that, you know, that they are going to have money, you know, earmarked for them in the will that's going to be, you know, transferred to either a trust account on their behalf, or there's going to be a guardian that's going to be entitled to some of the proceeds that they can use to take care of that minor. So these are all sort of things that if you're at the stage in your life where you have minor beneficiaries, we approach that differently, you know, and because this element of guardianship, this element of not being able to own property, we want to take that into consideration so that if you passed away while they were still minors, there would be a process in which money would be available for their care.
And just, I know we're going to get into guardianship, but just when you're talking about gifting, I think that's a really interesting topic that people have a lot of questions about. So you talked about how gifting would prevent something from becoming vulnerable, I guess you could say, to probate tax. But does it also become sort of less susceptible to income tax or other taxes if, let's say, I was to give a cash gift before death versus making it part of my estate?
Yeah, I mean, so cash gifts, are going to be, you have to, you have to basically think about where is this cash coming from. If you're going to be selling shares, or if you're going to be taking money out of a savings account, that's one thing. But if you're going to be doing anything that triggers a capital gain, then that money, whether it's gifted or not, is going to be subject to taxation. So, people can give sort of, certain amounts to beneficiaries through their lifetime, and that's certainly a way of sort of depleting the funds in which they were going to sort of give to them ultimately on their death. But a lot of people don't do that for reasons that they don't know how much money they're going to need, and they don't want to sort of pay advance gifts to their beneficiaries. From an estate planning perspective, most people would prefer to control the funds until they're not around anymore. And so, from that perspective, gifts are certainly one of the ways that you can, move money to your children to avoid probate tax, because it never enters the estate. The question of whether that money, or whether that transfer results in a taxation event, is going to depend on the source of those funds and other things that your accountant would be able to work with you about.
There is one more question, Dan, that may be an accountant question, but thinking about if I am I'm just going to use my example. If I am a joint tenant on, let's say, and I already have my own principal residence, and all of a sudden, if someone passes and I become the sole owner of that now second property, no longer a primary residence, does that trigger capital gains if I wanted to sell that after, let's say, a parent passed?
Well, yeah. So, if you think about the principal residence exemption, from a capital gains perspective, is really an exemption to the rule that capital gains always applies on the disposition of an asset. And the calculation is basically your adjusted cost base, what you acquired the property at, and then what you sold it at. And, whatever's in between is taxable. That's the basic deal. And to the extent that you have lived, that you have a principal residence that could be subject to that exemption, you can take advantage of that. But as I'm sure everyone is aware here, you only can elect one property. So in the event, for instance, you're transferred, this is one of the reasons why not everybody may why it doesn't always make sense to just add multiple people to multiple titles, because they will be paying tax ultimately on all of the properties that are not exempt. So that is the answer to that question. I think is basically you only get to choose one, and one that you live in frequently.
Okay, thank you. We are going to move on to talk about minors, which you've mentioned. So if you want to just give a quick overview of minor children and guardianship.
Yeah, so when you have minor children, either your children or maybe your grandchildren, that you want to ensure are taken care of in your will. Um, you know, one of the things you do is, you instruct, and this is by sort of, this is the default, way of doing this. This is not like a more complicated thing, but in the will, there is language that deals with how the executor is supposed to deal with minor beneficiaries. And that can involve setting up a trust account wherein the money that is earmarked for the benefit of those children is put and can be invested, can be put in a long-term GIC. The executor can have broad sort of discretion in terms of how they manage that money, trying to ultimately, take advantage, trying to use that money to the guardian's advantage while it's sitting in that account, and to also having a fiduciary duty to those minor children to not mismanage and not take unreasonable risks with those funds. So that's one of the jobs of an executor, and another reason why you want to appoint someone who shares your threshold for risk and also has is financially trustworthy and responsible. So one of their jobs will be making sure that that money stays in that account, that it generates income, continues to accumulate, and then ultimately is going to be released to the beneficiaries when they reach a trigger age. And you decide what that is after 18. A lot of times these days, especially, it takes longer to grow up in our world. So parents will designate a higher age. They'll say maybe 25. Maybe 21, whatever they're comfortable with. But the trustee will have the authority to use those funds as well for university, for educational purposes, things like that, if necessary. So that's one way that we deal with minors, or even people that have reached the age of majority, but are for reasons that you've selected, don't want them to be entitled to their inheritance at that age. Guardianship is a way that you can appoint someone to be the legal guardian of a minor child if you pass away and you're their guardian. So it's another way to ensure that the process doesn't have to go to the court and go through a process of appointing someone based on applications in the court. It's just another way to reduce the administrative overhead of trying to make sure that your kids are taken care of. And so for a job like this, obviously it's a big role. All the same, recommendations apply about trustworthiness and someone you think can do a good job and cares for the kids. But I think this is an even more serious role, and one that you should always talk to them about in advance. Because of course, if they're not up for it, you need to know, because they don't have to accept that position, and then it sort of throws it back to the court to sort of decide. So important to have these conversations with your electives in all the roles, but especially if they're going to be taking on something like that. And then we have here, charitable donations as well. I can touch on that. A lot of times people have a couple of charities that are important to them. I think that's great. I do think that sometimes the will can get bloated with a lot of different sort of small amounts going to a lot of different charities. So I think it's again, just think of how much time that's going to create for your executor. Trying to keep the costs down. You want to make sure that you pick some charities that are really important to you, and that you designate a dollar amount or a percentage, and that the rest go to your beneficiaries. That's generally what I recommend. We can move forward.
Yeah. So the big thing, we wanted to talk a little bit about steps to get started. So what can we do now to get going if we're in the percentage that maybe hasn't done a will in a long time or doesn't have one at all?
Well, the first thing is to, obviously depending on what, people answered the polls in different ways. So we have some people that have wills that were done quite a while ago. We have some people that that don't have wills at all. I would say for let's go through it. So for someone who, if you did a will, 10, 20, 30 years ago, I think it's a good time to take a look at that will, and you may not have it with you. It may be with your lawyer, and that lawyer may not even be around anymore. And so that's a question we get. And I try to not take it too personally when the clients sort of are predicting my death, but they're saying, well, what if we can't find you in 10 years? And I hope to be around, but the reality is a lot of lawyers will not be. And so there's a couple ways that you can get your will, and one of those ways is contacting a law society and just saying, my lawyer passed away. Lawyers have a responsibility to transfer their files to either a new lawyer or to the law society for carriage. And so the law society will likely be able to put you in touch with where their files are now. Another way is that you may, even if your will has been sitting in an office and that you haven't spoken with your lawyer, you might want to touch base, and you might want to get a copy of that will, and you might want to take it to a new lawyer, a lawyer that you're working with, who may be younger, who's going to be, obviously have a longer career, hopefully, and so that might be a better place for your will. Either way, if once you get a hold of a will that's been created, if you're not happy with the way it is, or even if you want to review it with a lawyer to just make sure that it still reflects those things, you want to contact an office like ours, and you want to just let them know, we have a will, it's at this law firm, we'd like to get it, and we'll write to them. We will request the release of that will, and then we'll get a hold of it and we'll review it with you. If you don't have one, we'll draft one from scratch. We have, an easy questionnaire sort of intake process where we leave all the legalities out of it, and we just focus on, getting the in normal language, how, who and what. And so that process starts with you taking an inventory of what assets you have, and those are going to be a combination of property, bank accounts, insurance policies, and cars, jewelry, things like that, and then you're going to essentially get an idea of what you want to and what you want to do with those assets, and whether there's going to be specific transfers to people, or if you just want it all to be treated like cash in your estate, and you don't have any specific sort of bequests, as they're called. The next thing is, who do you want to act? And this is that question of, well, who is the best person to act as trustee to make sure that all my wishes and instructions are handled properly, and that's part of the thing we discuss with you. The natural appointees are going to be your spouses, but adult children often are a good option. And like I said, there's also your lawyers or accountants or financial advisors as well. You want to think about outside of the will for your power of attorney for personal care. You want to think if there's any restrictions or anything you want to include that's going to guide your attorney. So you're going to think about, well, how do I feel about being on life support? That's a big one. How do I feel about resuscitation? And so these are things that can be communicated, or they can be left to the better judgment of your attorney. And then for property, power of attorney for property, you think about, well, do I want to leave an unrestricted power of attorney for property, or do I want to restrict it to certain property, even for a certain period of time? So these are all things that we kind of, will talk to you about. And we'll have that discussion based on your specific needs and your specific life, with the variety of different relationships you have and the kinds of assets that you're dealing with, in order to try to keep it simple and make sure that it fits, what your lifestyle looks like. So I think that's an important part of the relationship between you and the lawyer who's drafting these on your behalf.
That's great, Dan. Thank you so much. There are a couple questions that have come in. Just briefly, someone was asking what it costs to get a will created.
So we have one of the things that I think we're going to be handing out is a breakdown of sort of our basic fees for these things. And so Anuja, how's that work? Are we going to be handing that out after the?
Yeah, it'll be. I can attach that to the email for tomorrow, so I can send that along.
Yeah. So, but basically, just to give you a basic rundown. So for our, we do generally recommend that wills and powers of attorney are drafted together, and we offer sort of, preferred rates for that kind of thing. And so for, let's just say, a basic will and power of attorney for personal care and property for a couple. Okay, we charge $949 plus HST and disbursements, which are going to be minimal on this kind of thing. But we're talking about if there's couriers or if there's things like that. But basically, $949 we charge for an individual. And so in that scenario, you both get two wills, or you both get a will. So there's two wills in total, and then you both get powers of attorney for personal care and property. So 4 powers of attorney in total. Now for doing it on an individual basis, we charge $549 for the same thing, a will and 2 powers of attorney. And we also do, it's $99 for just a power of attorney on its own, and a basic will, we charge $399. So, you're looking either way under $1,000 for getting set up for you and your spouse, or just yourself. Now, when we're talking about the estate, so the process of administering an estate once you're deceased, the executor would come to us or a law firm like ours, and that process is a little more intensive, involves more administrative. There's more paperwork. It depends on what the situation is and whether you died with a will that has issues, that wasn't executed properly, etc. But in general, our fee for administering an estate would be $24.99, which involves our preparation and submission of the application of certificate of appointment of estate trustee with or without a will to the courts, and we work with your executor to make sure that that whole process is complete, and that ultimately they've discharged their responsibilities as an executor. So that's a bit more of a bigger project, but the wills and powers of attorney, those fees are going to be a lot more approachable up front.
Okay, perfect. Thank you. And I think we're offering a discounted rate for people who attended today. So I'll include that in the email tomorrow. But
that's
Dan, I'm just...
That's fine.
Oh, well, I've twisted your arm now. So
no, that's great. If anyone comes from the, calls my office, just let me know you read our seminar, and I'd be happy to offer that and appreciate the referral.
Perfect. Well, just a couple more questions. I'm aware of the time, Dan. One quick question that came in around digital assets. So things like Bitcoin, passwords. Do you run into problems, or are you noticing a change? I know we recently, in our family lost someone who wasn't prepared. And I think not knowing what accounts there are, David started a folder that it's called the death folder, unfortunately, but that's what it is. It's really an opportunity for us to have access to each other's, accounts, passwords, all the things that we might need. Are you finding that as an important sort of exercise for people to do?
We're not only because of it's going to become, one of the biggest challenges of administering will, because people who have have been establishing quite a large digital database of assets or accounts, even video libraries, things, anything that could be valuable or things that they want transferred. These are going to be things that as the generation that has these things starts dying, they're going to, their trustees are going to be going, well, where do we start? Now, I think it's important to keep in mind that not all of these things are going to be involved in probate for all the reasons we discussed. They don't necessarily need to be part of the estate that gets, transferred. But things that, the location of accounts, account numbers, any security codes for access to lock boxes, or things like that. Those are things that you want to put in your will and that are going to, as on the side at the end of the will, that are going to help your executor find these things and get access to them. There are going to be things like bank accounts, that where they're going to have to, either show up or send along your proof, your death certificate, as well as a copy of the will, in order to get access to those things. But certainly, if you're someone who has accounts in different countries or a variety of different banks domestically, you want to include as much information along with your will that's going to be kept confidential at your lawyer's office or wherever you're storing it. That includes how the executor can get to these things and make sure that they can find everything. So that's a good point.
Great. So just one last question, Dan. Is there a strategy to avoid paying the capital gains tax on a property, let's say, owned free and clear by older parents who want to leave their house or its value to their kids? So is it better potentially to sell while living, and so there is the capital gains exemption, and then gift it as cash? Or is there a way to use a family trust? What would be a way to sort of avoid some of that?
Well, okay, so I think that you have to, it really depends on what you need, and whether or not gifting something like a house, or with the value of a property during your lifetime makes sense from your perspective, because most people don't have that kind of liquidity or that kind of cash, and also most people are whatever money they have is tied up in investments, etc. So I think the best way to think of capital gains is that it's true that you're not going to make capital gains when ultimately the transfer happens of property that you are entitled to an exemption. And that's going to be, keep in mind, that's going to be either at your death or during your life. That doesn't matter. You're going to be entitled to that exemption either way. And so from a capital gains perspective, it doesn't really matter when you transfer it, whether it's going to be through your will or, and the person that's going to be acquiring the property from you by way of a gift or otherwise is going to be acquiring it at the fair market value if it was a gift. Okay. So then they're going to go on and pay tax whenever they go to sell it based on if they had paid, that value in cash at that time. So I don't think it really matters.
Doesn't help.
It's more about what makes sense for you, and what you have the flexibility to do.
Great. Thank you. Sorry, one question I couldn't see. Do we need a separate will for assets that are out of the country?
So the answer is a little difficult in that it depends on. So sometimes people will have multiple wills, because you have to think of the will as the instrument that allows you to transfer assets that require registration, to essentially, like, there's like a registry. And so without that will, you don't have the necessary authority, or the executor won't have the authority to transfer something within a registry. And that's like land, mostly land, and maybe your inventory, or whatever. But so you want to have a will drafted in any location where you own substantial assets that are going to need to go through some kind of probate process. And so that could mean that you have one in Ontario and in Manitoba, and you have one in Texas. And it really depends on where your assets are located.
Okay.
Now, why it's sometimes complicated is because nationally, there are national banks, for instance, where you can have an account at a local transit, like in a bank in BC, but it's at RBC, and they also have branches in Ontario. So probably there's not going to be a need to have a will in BC as well, because RBC will be able to sort of deal with that in Ontario as well. So it depends, but in general, anytime, especially you own property, that's going to be something where you want to consider multiple wills. Because each state or province, in other words, is going to have their own administrative process for transferring that property.
Perfect. So I think the main message, Dan, I heard loud and clear from you, and I hope everyone who is here today and watching, is the importance of starting now. In real estate, I talk about moving by choice rather than circumstance, and by not waiting for circumstances to get sometimes hairy and difficult, to sort of be proactive. And I think you've really hammered that home for us. I will be sharing your contact info in the email tomorrow, so you guys can all look out for that. And a reminder again that part 2 will be happening just in January 28th, and it'll be decluttering for seniors, practical tips for a happier, lighter home. So you can look out for information on that as well. I want to thank you all again for joining us. Dan, I just want to thank you so much for your time. I think a lot of people got a lot out of today, and I just appreciate you so much, and for sharing so generously with us today. My information is here if anyone would like to get in touch or follow on Facebook and Instagram, Seamless Rightsizing, and you can look out for an email tomorrow with the recording and some assets and some items from Dan and from myself. So thank you again to everyone for joining, and Dan, thank you one more time.
Thank you guys so much for having me, and thank you everyone for being with us tonight. And please feel free to reach out if we can help.
Perfect. Thanks so much. Good night, everyone.
Sure.